Good afternoon. I'll call the case of 112765 Diana Hilburn versus Interpipe Ltd. Counsel, please state their appearances.
Thomas Warner, Your Honor, for the appellant Diana Hilburn.
Andrew Holder on behalf of Appellee Interpipe Ltd.
Toby Krause on behalf of Intervenor State of Kansas.
All right, thank you. Mr. Warner?
May it please the court, my name is Thomas Warner. I represent the appellant Diana Hilburn, and I would respectfully request 5 minutes for rebuttal.
5 minutes is granted.
Okay. As this court is aware, this case was a auto truck collision that resulted in a jury trial, and a jury rendered a verdict in this case for economic damages that exceeded the cap provided by KSA 60-19A02. The trial court reduced the amount of the non-economic award to the amount of the cap over my objection, and we appealed based on the Kansas Constitution, namely Section 5 and Section 18. And so it's our position.
About $51,500.
Yes, sir. Yes, sir. And I would suggest whether it was $5 million over or $1 over, it still impacts the constitutional rights of my client and other people similarly situated. KSA 19A-02 is a statute that was drafted by the legislature that's outside any comprehensive legislative scheme. It's a statute that applies to all tort cases regardless of the category of tort cases, whether it's medical malpractice, whether it's auto, whether it's products liability, dog bite, general tort litigation. It applies to all of them. In no way has it ever been part of any comprehensive legislative scheme as it relates to general tort cases or any tort cases for that matter. And Section 5 of the Constitution clearly provides that the right to a jury trial in the state of Kansas shall be inviolate. And I think the word inviolate is very, very clear. I think the court understands what that means. I think that the case law that I cited in the brief is very clear that it means undisturbed.
Does that distinguish this case from what the 14 or 15 other states that the state is arguing has found that there's no violation of the jury trial right?
I think it does, because I think that language is very clear and very strong. And it's the same language used by our sister state, Missouri, and the rationale behind their finding in the Watts case that a similar statute violated its state constitution. So I think that's where we start. And then the question becomes, okay, what is the purpose of a jury trial? What is the role of a jury? And the role of a jury is to determine what the facts are. And one of the facts that are determined by juries is what the damages are. In fact, that's what we tell them when we try cases. When you look at the jury instruction handbook for jurors, they're told that they will be making the decision on the facts of the case. When they are instructed, they're told by the judge that one of their roles is to determine the amount of damages.
Counsel, can we back up from the fact-finding role of the jury just for a second?
Yes, sir.
And let me ask you, in this case specifically, where do we look to discover the remedy available to your client?
The remedy?
Yeah, where is the remedy defined?
It's in common law. The remedy is based on common law.
So there's no statute that provides a remedy for a personal injury action in this case?
Well, in the case of, I suppose the Automobile Injury Reparations Act talks about that, but the right to make a claim in an auto case is based on common law. It's a tort.
And that's not been superseded by any statutory provision.
That's my understanding, Your Honor. That being the case, when you look at Section 5 and you see the language that was chosen by our the people of the state when the state was being formed, I think that becomes pretty critical to the analysis. Because we have to ask ourselves, all right, if the right to a jury trial is inviolate, what does it mean when the legislature steps in and says, we're going to put this cap on non-economic damages and essentially take that away from the fact-finding job of the jury? And not only that, in the statute, the legislature has instructed the Kansas judiciary that we cannot tell the jury that in reality their fact-finding role is not what they're told when they are instructed. The fact is that if the jury decides in their wisdom that the non-economic damages for a particular party should be more than $250,000, they're not told that.
What's the implication of your position? I understand that when the law reduces the damages, we had a case this morning that called for doubling the damages. We have treble damages. Does that interfere with the jury's inviolate right to determine the damages?
No.
Why not?
Because I think that if there's a legislative act that says that you take what the jury has decided, and for whatever reason, there's got to be some basis for that, the legislature thinks it makes sense to double or triple those damages, I don't see how that would interfere.
Isn't that exactly the same thing here? Arguably, you got the jury's damage award, and the legislature says for whatever reason there's a post-verdict adjustment.
Well, that's a legislative act, and what we're talking about is the Section 5 and Section 18 constitutional rights. I think if the legislature decides to draft a statute that augments the damages, I suppose that's within their prerogative.
What about a statute that protects assets?
That
You
protects
get your judgment, and you're saying you have a constitutional right to collect that judgment. Then statutes that restrict your ability to garnish or to provide homestead exemptions or bankruptcy even would seem to be interfering with this decree that the jury has given, this fact-finding that the jury's done. So aren't all those statutes unconstitutional?
I don't think so.
I don't understand. That doesn't make sense to me. I mean, if the jury's verdict is supposed to be inviolate, and you're interpreting that to mean collectible, then when the legislature passes a law that keeps you from collecting because they've protected assets in some way, that's got to be intruding into the same jury determination.
Well, this idea of it being collectible is interesting because just because you get a jury trial verdict doesn't mean it's collectible per se. I mean, certainly we would hope to collect it, but there's no guarantee of that. The only guarantee we have is the right to a jury trial is inviolate, and what we tell the jury is that the amount of damages that they come up with is within their sole discretion.
Unless it's a doctor, and then you've got the insurance mandates, or a truck that's got insurance mandates, and so you're at least going to collect up to that amount.
Hopefully, that would be the idea.
You're not, though, making a legal argument for me as to why it's constitutional for the legislature to protect assets against judgments. And yet you say you have the right to be able to collect a jury verdict, or else it violates Section 5.
What I'm saying is that the cap statute violates Section 5, and it pays lip service to the form of a jury, but it robs it of its function. And if the function of the jury is to determine damages, then we ought to allow them to do that, because that's their job, and that's what we tell them their job is. And that was the intent of the Constitution. Now, if the legislature decides they want to have some additional statutes regarding garnishments and things of that nature, I don't really see where that implicates the Section 5 inviolate right to a jury trial.
What we're talking about is reducing the judgment, not reducing the collectability, right?
Right.
Because you have the same problem with the $250,000 in non-economic that you would with $301,509 as far as collectability.
That's right. The collectability issue to me is completely outside and isn't even triggered unless and until, in a case similar to this, the jury renders a verdict for a particular party, and in the case of the cap statute, renders a verdict that exceeds the arbitrary number selected by the legislature to cap non-economic damages.
Related to collectability, in your view, does the legislature have the constitutional authority to change the remedy that's available to injured people?
I think that they arguably do, and they have, and they've done that in the context of workers' compensation.
Sure.
And interestingly, what they did was they put together literally a comprehensive legislative package that says there will be no jury trials. We're changing all the rules, and now people who are injured in the course of their employment, who did it to themselves, who were negligent themselves, everybody gets compensated.
That's kind of the quid pro quo analysis, right?
Yeah,
Take something with one hand, give with the other. My
think-
question maybe is more blunt, I guess. Let's say they don't give with the other. Do they have the constitutional right just to modify, even if it's everyone in this room perhaps would say, well, that's totally unreasonable. Do they have the constitutional authority, though,
It's been
to
established-
just modify a remedy, just change it?
No, not without giving a substitute remedy.
And why not? Where
satisfying-
do you root that position in our constitutional law? Is that rooted in Section 18? Is it rooted in Section 5 or somewhere else?
Section 18, right to remedy. Because in the work comp context, there's no right to a jury trial, so Section 5 is not implicated. With respect to, for example, no-fault auto, with respect to making a claim for injuries, but they're minimal. The legislature provided a remedy within the statute, that says that you can get your wages and you can get your medical bills, but you can't make a claim for pain and suffering. But they've given a remedy in return for that. In Diana Hilburn's case, what is it that the legislature has given her in return for encroachment of her constitutional right to have a jury determine what the damages are, which is a fact question? And I think the Kansas case law and other case law is very, very clear that when juries determine facts, one of those fact questions is the damages question. And yet the legislature in this case drafted this statute that very broadly and generally applies to all tort cases. And I think in the context of Section 5, that violates the inviolate right. And what I see happening here is, on this quid pro quo with respect to Section 5, I don't even think that applies. I think quid pro quo should apply only to Section 18, where they can take something away from you but give you something in return as long as they meet the criteria.
They took away your right. If you were an employee before workers' comp, you had a right to a jury trial when you got hurt by a fellow employee. And they took that away. So this inviolate right wasn't inviolate.
But
I don't know. I've never been able to reconcile that. And if I could, I'd probably have written Miller differently. But I mean, that is the hang-up for me, and nobody on your side of the ledger ever answers that question well. How do you take away your right to go sue somebody and get a jury trial if it's an inviolate right? And if you can take it away, why can't you just modify it a little bit in exchange for something?
Well, that's what this court has decided over the years in the Rahala case and Manzanares. There's no question about that. But I think that those were comprehensive legislative schemes that changed the rules for everybody. Diana Hilburn still has to have a jury trial. She still has to file a lawsuit. She has to take depositions. She has to try the case to a jury. She has to hire experts, and we have to get a verdict.
And she has to collect it.
Pardon me?
And she has to collect
And she has to collect
in
it.
In the workers' comp, you just go to the mailbox and pick up your check.
That's right. That's right. And I think that
There's
is a
another
material.
distinction, Counsel,
Sorry.
there's another distinction too on workers' comp as well, because it took from both sides of the lawsuit.
That's
and
true.
it gave to both sides of the lawsuit.
Right.
I mean, everybody lost something, but everybody gained something.
And I think that's the definition of quid pro quo. And I think that
How is that reflected here? That's different from what's going on here, isn't it?
The
Because
only-
the only person losing out in this is the plaintiff's side.
Diane Hilburn, right. Absolutely. There is no commensurate quid pro quo, and maybe that answers your
Well,
question.
it's more than quid pro quo, because quid pro quo is only focused on your client.
Right,
It's not talking about the other side.
right.
And that's distinguishes workers' comp, for example, which is kind of the shibboleth here. That's what distinguishes it, is that both sides gained and both sides lost in the workers' comp scheme. Not only is it comprehensive, but it dealt with both sides of a lawsuit.
Both sides give something up, both sides receive something in return. And perhaps that answers your question, Justice Miles.
That's not the definition of inviolate. That's my problem. I mean, it doesn't matter whether you give both sides something or not. If this is inviolate, you don't touch it. Period.
Well,
You don't trade things off.
But
And-
we're
and
not,
That's what I can't figure out.
not every litigant has a right to a jury trial.
that's
If
exactly
you have a
right.
mortgage foreclosure, you don't have the right to a jury trial, right?
Correct,
But if you did, and workers' comp, you don't have the right to a jury trial.
correct,
But if you do have a right, then it's inviolate.
right.
I mean, that's the answer to that, is not
Essentially.
everyone has a right to a jury trial, even before workers' comp.
That's correct. And I think that makes perfect sense, Justice Johnson. So that, in a situation like Diane Hilburn finds herself in, what was it that the defendant gave up? What is it that defendants give up with respect to any sort of a trade when it comes to non-economic damages? Absolutely nothing. The only one giving up anything is the person that the jury said should receive those damages after a fact-finding jury trial in which the jury is told that this fact is something they can determine and the amount is within their sole discretion. But that's not how it really works. We're basically misleading jurors. We're telling them they have this job to do, but if they do it past this particular arbitrary point, we say, no, we're just going to arbitrarily take that away from you. And to me, that is the definition of the violation of an inviolate right to a jury trial.
There are other questions?
Thank you.
Mr. Holder?
May it please the court, I'm Andrew Holder. I'm here representing Applee Interpipe Ltd. Miller versus Johnson teaches us that the legislature has the authority to enact legislation that modifies a common law remedy without violating Section 5 or Section 18, so long as the modification is in the public interest and so long as the legislature provides an adequate substitute remedy.
Where do those latter two parts come from? I mean, you recited the case law correctly, as far as I can tell. I just don't know where those add-on requirements come from, other than just...
As best I can tell, the add-on requirements originated at least jurisprudentially with Manzanares, where they talk about the idea that due course, or a remedy by due course of law, means that, first of all, let me back up and talk about what it doesn't mean. It doesn't mean that when we pass Section 18, the precise remedies that were available at common law will remain exactly the same for all time and eternity. When you look at Manzanares, one of the things that the court talked about at some length in that case was the notion that the common law is meant to evolve and it's meant to change. And so when we passed Section 18, we didn't intend to preserve the common law exactly as it was in 1859. What we intended to preserve was that there would be a right to a remedy of some kind. And so when Manzanares talks about the fact that you're not necessarily guaranteed the exact right that was available at common law in 1859, but you are guaranteed a remedy. So if you're not given the one that used to exist, there has to be something else in its place. And so in my mind, that is where the addition of an adequate substitute for the common law remedy comes in.
Can you explain to me, on the second step of wherever the steps came from, the second step, your client, where did the Kansas legislature do anything that had your client requiring your client to provide something over to the plaintiff in order for her to give up her ability to collect her full amount of damages?
I would say that with respect to my client specifically, what the Kansas legislature did was they delegated to the KCC the authority to enact regulations regarding motor carriers, and through that, the KCC required my client to carry motor carrier insurance. So my client's required to keep and maintain that as a condition of doing business in Kansas.
Other than they were required by federal law to have that amount, and that's all the KCC stuck on there.
Well, it's true that they were required to do that federally as well, but by enacting a regulation in Kansas, we made it enforceable in Kansas, and we made it a crime to violate the federal regulation.
And
under
one other
Kansas
question
law.
one other thing I didn't understand yet before was your client being an out-of-state trucking company. Are you subject at all to what the KCC does? Aren't you either subject to wherever your base is, Texas, and or in federal law?
Well, I believe that the KCC regulations state in this case that to the extent an out-of-state trucking company is doing business in Kansas, they have to file proof of insurance with the KCC.
Are they doing business in Kansas if they're driving through on I-70?
Well, I think it's part of, I do think that traveling through Kansas is part of their over-the-road trucking company businesses doing business in Kansas.
Excuse me.
What public interest is being met by this, by your side? You said that there's an adequate substitute and there's a public interest component to that. I understand, at least it's articulated in the medical mal field, when that was adopted, was there was a shortage of physicians. The cost of medical malpractice insurance was escalating. What do we have here?
Well, I would say that the public interest is comparable to the medical malpractice in Miller in that we're trying to encourage drivers in Kansas, whether it's drivers of normal motor vehicles or drivers of motor carriers, to carry the insurance that Kansas law says that they must carry.
And so isn't that a minimum of $25,000 in liability coverage?
Well, it's for regular motor, I guess for regular drivers, that's true. But in addition to that, there's also the first party coverage.
And why was encouragement necessary? I know my email is full of ads, my mailbox is full of ads, I get calls from a plethora of insurance company that wants me to buy automobile insurance from them, so I fail to see the crisis here, or do you think that was all generated by the caps?
The reason that it was necessary, if you go back to Manzanares, it talks about the Citizens Report and how they examine liability insurance generally, and how the fact that there are uncapped damages on uncapped non-economic damages made it difficult to write insurance, and it made it difficult to predict the appropriate premiums that people needed to purchase, which in turn made insurance more expensive. And so
I don't understand that. What is the difficulty? If they run actuarial assessments of likelihood of accidents, likelihood of damages, if they can assess how likely it is that there's going to be non-economic damages of $250,000, then they have the formula or the algorithm or the means to determine how many will be $301,509. I mean, if you have the means to set a premium for that, you have the means to determine what the premium should be on what would be an average non-economic jury verdict.
And all I can say on that is that if you look at Manzanares and you look at the report, what they talk about is that there were still difficulties predicting that. And so their goal, whether it actually came to pass or not, I can't speak to that, but their goal when they passed the caps and the idea behind it was that it would make it predictable, or more predictable than it was uncapped.
So the predictability, though, was specifically for the benefit of insurance companies, right? Because it's not for the benefit of the ordinary driver, is it?
Well,
I mean, we don't Why would we care if tortfeasors have to pay?
I would say that the answer to that is theoretically, if non-economic damages are more predictable, then drivers who are required to purchase the insurance will be able to more appropriately select the
So it's helping the lucky drivers who don't end up getting hurt by one of these tortfeasors. I mean, that's what you're saying. It's all about the regulating the insurance market.
It's about regulating the insurance market so that insurance will be more affordable and more available.
It arguably drives premiums down for everybody. That's
Right,
what you're
exactly.
saying.
And so that's
And I guess I still need some explanation. When one purchases automobile insurance, one of the questions to be asked of the potential insured is what kind of liability limits do you want to carry? Okay? And as my colleague started to allude to earlier, the state only sets rather minimal limits. And so if someone picks 100, 200,000 liability limits, which is 100,000 per person, 200,000 for the total accident, how does the $250,000 cap on damages come into play for that insured?
well,
And why aren't they determining predictability of or how they need to charge premiums for those limits at which they have to pay out, regardless of what the total non-economic? You understand my question here?
I think I'm getting a little lost there, but I'll do my best, and you can tell me if I'm getting off
Okay.
course. I think that the answer to your question is, number one, when we're talking about step one of the quid pro quo test, it's not a matter of the nuts and bolts of does it actually lower premiums or does it address that. It's whether there's potential for it to do that. And so that's where I think.
And that was my question. How did you have the potential to increase the availability of 100,000, 200,000 automobile liability insurance by putting a $250,000 cap?
I would say that it just goes to the ultimate premium price that they have to pay, because the insurance companies know that the most non-economic damages that can be awarded regardless is $250,000.
That exactly. Now you're getting exactly what my question is. And if the companies are setting liability limits and they are charging premiums based on the limits to their policy, why is it they need to know how much the non-economic damages are going to be in any particular accident? Because they're only going to pay their limits. And you charge the premium for the maximum that you will have to pay out. And that's what you're saying. They need to know how much the economic damages, non-economic damages are, so they can know what to charge when they have to pay that out, but they don't have to pay that out if it exceeds their limit. You understand what I'm saying?
I think I understand what you're saying. I don't have an answer to
He's
that
just
question.
saying that for the segment that choose liability limits less than the caps, your rationale falls apart. Is that clear?
Yes. I want to just touch on for a minute the two substitutes that are in this case and how they relate directly to the substitutes in Miller versus Johnson. In Miller versus Johnson, what we had was mandatory insurance required by the HCPIAA. In this case, we have mandatory insurance that's required by the Kansas regulations. It's KAR 82-4-3N. And the reason that those are directly comparable in this case is because in Miller, when we considered the adequacy of the substitute remedy, what the court relied upon was the fact that there was a guaranteed source of at least partial recovery because the law required the defendant to have liability insurance. And that's the same thing we have in this case. Because Kansas regulations required Interpipe to have at least $750,000 in insurance to operate in Kansas, Ms. Hilburn had a guaranteed source of, in this case, full recovery for the amount of damages entered by the jury.
Presuming lawful operation by your client.
That's absolutely true, but I would note that that's the same as it would be in Miller as well.
Exactly.
Meaning that the doctors could theoretically decide not to obey the law, and we'd be in the same position we would be in this case.
Right. It doesn't hurt your comparability argument.
So the second issue that the second source of recovery in this case is the personal injury protection benefits. And what we're talking about there is after this accident happened and before liability was sorted out, before damages were sorted out, Ms. Hilburn had the direct benefit under Kansas law of the fact that she could submit a written claim to her insurer and she would be guaranteed a source of recovery immediately for her medical damages, for rehabilitation services, for disability and things of that like.
That's first-party insurance.
Right.
She's charged a premium for that.
That's true, but I would note that
If she had health insurance, accident insurance separately, that would pay her too.
that's
And
true.
So I don't understand how that fits in your calculus if someone buys their own protection, that gives the tortfeasor the right to have a cap.
Well, and I would say to that I believe it's in Bear, the court talked about the fact that even though insurance is required to be purchased, if Kansas law requires it to be purchased by the plaintiff, that is part of the substitute remedy we consider. So I would say that the fact that she has PIP benefits is a source of recovery because she got those regardless of the fault and she got them promptly.
Let me ask you in relation to these two items. There's no direct linkage, maybe with the PIP, but let's focus on the mandatory insurance from the KCC. There's no linkage between it and the cap that I can see. I mean, this isn't Miller, where you've got a comprehensive scheme and doctors and all that stuff, and then the limits are all part of that. This is, or even workers' comp. This is the state basically requiring the same thing that the feds require, but there's no linkage between that mandatory insurance and the legislature's decision to cap the plaintiff's damages.
I think that there are two parts to this answer. The first part would be in Miller versus Johnson, the court specifically said that number one, the quid pro quo need not be contemporaneously enacted with the statute that modifies a remedy, and two, it doesn't even need to be part of the same statutory act. And the second part of that, of my answer to that would be, when KSA 60-19A02 was enacted, that specific statute was enacted with the idea of controlling the entire insurance market, not just healthcare. And so the idea behind it is that, again, we want to make all types of liability insurance affordable and available. So I think that there is a direct link between mandatory liability insurance of any kind and the cap. With that, I see my time's up. I'm happy to answer any other questions that you have. Otherwise, I will go ahead and rest.
Any other questions? Thank you, counsel.
Thank you.
Good afternoon, and may it please the court. In 1988, the Kansas legislature considered a variety of policy questions before it and enacted KSA 60-19A02. It did so. This court has been presented repeatedly with opportunities to strike it down under the Constitution, changing the legislative policy through litigation, and that has come back before you today. We are here on behalf of the state of Kansas to urge this court to continue to uphold the constitutionality of KSA 60-19A02, and we have two principal reasons for it. First was referenced by my colleague, the quid pro quo test. This court's cases go back to Samsel, Manzanere, a long litany of cases. We believe that the Court of Appeals was correct in addressing that, correct in determining that this court's binding precedent requires judgment in favor of defendant and upholding this.
On both constitutional provisions, counsel, both section 5 and 18?
We don't take issue with the Court of Appeals judgment. That's right. So there is the quid pro quo analysis.
That's what I was talking about. You
Yes.
think it should apply in both?
We do not take issue with that before the court
Yeah.
today.
Okay, I hear
But
you.
you briefed why it shouldn't apply at all, didn't you?
We briefed in the alternative that if this court determines that the quid pro quo analysis applies and has not yet been met, then this court, if it's going to retreat from a particular section of its cases, it should reconsider additional cases, and that would be the applicability of, or how it has interpreted Section 5 and Section 18. And that's my second point, Your Honor, is if this court were to reconsider whether quid pro quo applies at all, that there are textual reasons that it could determine that the statutory cap applies in this case.
Let me turn you to those textual reasons and start with where I started earlier with your opposing counsel. Where do we look to find the remedy for an injured person?
So my understanding, and I think there are two aspects there. There's the remedy as specifically mentioned in Section 18.
So there's the constitutional remedy, but well, let me just cut to the chase. I'm not sure that it's found in common law any longer. We have a statute, 60-249A, which sets forth the remedy. It's a personal injury statute, right?
Yeah, and
isn't that the statutory definition of the remedy?
Yeah, and I think we would perhaps draw a distinction between remedy and damages. I think this court's cases has looked at, the facts are determined by the jury, and those are traditionally what happened, who did what to whom, what is the extent of damages, and I'm not certain that we can get from damages to remedy, and so equating.
Well, you're going where I'm going, and I'll just cut right to it. What I'm really struggling with here, what I'm really trying to figure out is whether 19A02 is part of, delimits the remedy that is available to injured persons, or if it is substituting legislative judgment for the judgment of the jury.
Yeah, I don't think it's substituting the judgment of the jury. I think the jury makes.
Well, here's why arguably it is substituting legislative judgment for the judgment of the jury. It's in a totally different statute. I mean, we have a standalone remedy statute that says nothing about limitations. And then I guess I'm really kind of hung up on the fact that the statute itself says the jury's not allowed to know about it. And that makes it look an awful lot like substituting legislative judgment for jury judgment, to me. Well, so help me work through that.
Sure, and I'm not sure that I can quite get with you on track, but as we would see it, it is a method of controlling the pace and flow of the litigation, just like the legislature would do, adopting rules of civil procedure, rules of evidence, statutory damage provisions, statutory liability provisions, things of that nature. So I think that is not invading the province of the jury, whether, for example, in the evidentiary objections context, whether you tell the jurors what is going on at the sidebar or not, the jurors are still presented a body of evidence that it must then determine.
I'm sorry, Counselor, are you saying just the portion that my colleague asked about having to do with not telling the jury is a merely procedural provision? Or are you talking about the whole thing?
I think I'm talking about the whole thing.
Okay. I just don't get that. I'm really puzzled by how cutting a damage award is a merely procedural thing.
Yeah, so there are a whole variety of things, I think, as then Justice McFarland talked about. There are a whole variety of ways in which, after the verdict is rendered, there are collectability issues, for example. There are bankruptcy issues. Those are...
Yeah, but collectability is different from having a judgment. You understood my colleague to my immediate left's question about that, I'm sure. He was distinguishing between collectability and judgment. I think your opposing counsel, plaintiff's counsel in this case, is saying we're talking about judgment, getting a judgment. Whether it's collectible or not, that's on us later. This is cutting our judgment. That's different, isn't it? It's different. It's more substantive than merely a procedural nicety.
Well, I'm not sure it is, because I think the facts that a jury would address is a fact. For example, was a plaintiff injured? That's a fact. What is the extent of the injury? That's a fact. Mm-hmm. What remedy is available? That's not a fact. That's a matter of law that I think the legislature has
But that
canon.
goes right to my question, trying to figure out, is this cap describing the remedy, or is it really taking a fact question away from the jury? That's a hard question. That's where I'm hung up. That's the question I'm hung up on. And if, I'll just tell you, if, for example, the cap was set forth in 249A and the jury knew about it, I think at least there's a strong argument it would start to look a whole lot more like a legislative determined remedy.
Well, I'm going to attack it somewhat different. I think there are a couple of rules of statutory construction that you need to look at. One is just because they don't travel together, it doesn't mean they're inconsistent or don't move to the same aspect, okay? So the fact that one is in 6019A02 and the other is in 6249, we don't believe is a material distinction with regard to that. And I've lost my train of thought on the second one, but I trusted it was a good
Well,
one.
Statutory canon.
No,
A
that's
different
right.
canon. Can you come
Yeah.
up with a
Yeah, so, the other canon, I'm sorry, was trying to read statutes in a way in which it would uphold them against constitutional attack. I think this court has a duty, and what we would urge is this court to read the statute in a way that would do so. And I
Are you
think
talking about our duty to presume statutes are constitutional?
that's right, and to avoid a constitutional conflict, reading a statute in a way that would
Well,
preserve
that
constitutional concern.
doctrine would kick in if we found an ambiguity, right?
If there is an ambiguity.
Constitutional avoidance is different from the presumption of constitutionality.
It is, but if your concern is that it's in a separate section, we don't know what the legislature was
So
getting
that
at.
may create an ambiguity.
It may create an ambiguity in which you would have to then return to the constitutional avoidance issue.
And how do you, if you read the 249 as the remedy that's there for the jury to decide, so how would we interpret the cap to avoid a constitutional violation of the right to jury trial under Section 5, other than just saying, no, it's not a violation? If we determine that creates a potential, how do you avoid that potential?
Well, I think, and that gets into, you asked, I believe it was plaintiff's counsel about that, the additional courts that have reached this issue. I think the majority of courts, both state and federal court, have ruled that the damage cap, both as Kansas has and other states have, that those are policy judgments of the legislature that are removed from the fact that a jury would traditionally be called upon to address.
Doesn't the jury traditionally called upon to address, decide the facts and calculate the amount that should be compensated to the plaintiff? Isn't that the traditional role of a jury? And I just don't see how this doesn't change that inherent function of a jury.
Yeah, so I think the jury would calculate the breadth of the injury suffered. I don't believe that the jury would get to the remedy that is then recoverable under the substantive
What's the
law.
purpose of determining the amount of damages and what the plaintiff should be compensated? Why do they even exercise that function?
Well, going back to the common law, the jury of the peers was an important concept so that common folks would have an opportunity to, I think at the time the example was the king or the crown or what have you, would have a jury of the peers to address the facts of the situation. The substantive law may change and can change, whether that be common law or statutory law. But the jury is to set forth and find those facts as presented in the case at issue. What remedy then is available under substantive law is a different matter.
Is the concept of additur and remittitur analogous at all?
Well, I think it is, and I think somewhat goes to the inviolate aspect of both the legislature and the courts have a duty to address what the jury does. Courts always have the opportunity, for example, to take away a jury verdict, order a new trial. The control that, I'll call it Article 3, actors have to control the operation and mechanism of a trial doesn't violate a right to a jury trial.
But
Here,
that's not based upon making sure the defendant stays in business. The additure or remediature has to do with what was actually proved, wasn't it? I mean, a court can't just say, I don't like that, that was too much. They have to base it upon the proof did not support the jury verdict, right?
Yeah, and I may not be catching you completely. I was trying to address the question about whether or not that violates, additor or remediator would violate the concept of a right to a jury. Our position is it wouldn't. I'm not, the basis for an additor or remediator.
I'm just saying that it seems to me that's apples and oranges. Whether the evidence was sufficient versus what damages were appropriate.
So they deal
in
with
this-
a proof problem,
A proof problem.
not just a mere matter of preference as public policy.
Yeah, so I do, if the point is additor and remediator different from a statutory damage cap, I think the answer is yes, but I don't think that they're distinguishable in what's going on. I think the jury, the right to a jury has still been honored when the jury is impaneled and renders its verdict. What remedy is available is a different matter, I think.
You mentioned all the other states that have determined that it's okay if the jury just decides damages. It doesn't violate the right to a jury if the remedy is something less. Is that what you're basically saying the other states have indicated?
Right, so there is probably 50 states have 50 different versions of the Constitution. I think the latest.
Well, that was my question, do you think that's a distinction without a difference?
As to what the particular language is?
Right.
Yeah, I think all of them, none of them are binding on this court. All of them are offered as persuasive evidence. The interpretations of particular language, for example, I think plaintiff's counsel indicated that Missouri has the exact same language. I'm not sure that that matters any more or less. It's just some evidence of how other courts have handled this situation. I think the Oregon case we cited was a fairly lengthy and scholarly attempt to address the right to jury trial, what that meant in common law, what that meant.
Speaking of that case,
Sure.
you're talking about Horton, right?
I believe that's correct, yeah.
Your opponent, plaintiff's counsel's response brief to your brief discussed Horton toward the very end, and then a subsequent Oregon case, which was from the Court of Appeals, Vasquez. Do you want an opportunity to talk about those? He limited Horton down. He said it was limited to its facts. I mean, do you agree with his description of what Horton said and then what Vasquez said later?
So a couple of things. I think we would say all of those cases from the other jurisdictions are persuasive authority. They're just some evidence of what other
Right.
courts do.
We got that.
Horton, I believe, dealt with both what I will call the Section 5 and Section 18 issue. My recollection is Vasquez dealt only with the Section 18 issue.
Okay.
And again, it's some evidence. Our bigger picture on the Section 18 move in there is the remedy issue. And again, if this court's going to reconsider what this provision of the Constitution means, remedy, I think, has a particular meaning. And if you look at the history of what that provision was intended to do, it doesn't have the word "a remedy" in it. It says remedy by due course of law. And so
Yeah, this is your argument about being an open courts provision rather than a kind of an open courts or independence of the courts provision rather than an actual individual right, giving rise to an individual substantive right.
That's right. So I see I'm out of time. If the court has any additional questions, I'd be happy to answer them.
Yeah.
Thank you.
Thank you. You reserve 5 minutes.
Thank you, Your Honor. I'd like to go to Justice Stiegel's question on whether the cap statute in this case is merely the legislature substituting its judgment for the jury's judgment. I think absolutely that's what's going on. It's a one-size-fits-all. The cap only applies to those people who have been the most seriously injured. Let's just face this. The cap doesn't apply in most garden variety cases. So it only affects those people who have suffered the most. And when you have a cap statute like we have in this case, after the jury has done their job, after they've been told by the judge that the amount of damages for non-economic rests within their sole discretion, then we've got the statute where the legislature says, well, that's nice and interesting, jury, that you came up with that, but we're going to arbitrarily reduce it down to this particular number. And it applies in cases where there's no insurance as well. Dog bite cases, maybe premises liability cases. Whether there's insurance or there isn't insurance, this cap is a one-size-fits-all cap for all tort cases. And so I don't see how you can look at it as anything else than the legislature encroaching on the constitutional rights of our citizens to have juries make these determinations. Any other questions? Anything else? Okay. Thank you for
Thank
this
you.
opportunity.
Thank you to all counsel. The court will now take this matter under advisement, and the